I do think he needs some jail time. He has some issues. He has attitude issues, and he has learned nothing from this entire thing.
I want the truth. You can't handle the truth.
Hello to my subscribers. I thought I'd pop in quickly and say, welcome back. This case is a classic clown, by the look of Goofy on his face with those pre-made dreads upon his head. We can assume that we shall be seeing this clown again. And what's his crime, apart from looking like this? Well, this unemployed, uneducated bum decided to beat up his sister over who can use the phone charger. And his lesson that he learns from this experience from being in prison and his consequences having actions, well, that would be the same for the hope for this guy to work at NASA.
State versus Jeremiah Day. And are you Mr. Day?
Yes, ma'am.
Did you understand in count 3, you're charged with tampering or fabrication physical evidence with intent to impair as a 3rd-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. According to the plea, the state is proceeding on count 3. There's a $500 fine. State recommends deferred adjudication. Court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Anything you wish to say on behalf of your client?
Yes, Your Honor. Mr. Day is 19 years old. He would like to work as a roofer potentially soon. He does not have a GED. He does not have a high school diploma. He would like to obtain one. And he does plan on moving forward being a more functional member of society. He's very young. He's going to be living with his mother. And I believe that he has the support available to allow that to happen. But I do think that getting his GED or some type of diploma would benefit him. I don't believe that there's any other mental health diagnoses that I'm aware of in speaking with him, aside from, I believe, ADHD, but I think getting his diploma would help.
All right. Have you ever had employment? Doing what?
Actually, yes, ma'am.
All right. Why are you arguing with your sister over a charger?
I mean, she started it. It was really that.
All right. I see now the reason why they're recommending the MRT. I don't know how getting into an argument with your sister, and how old is she? She's 16. You're 19. You're getting in an argument with a 16-year-old, and this turns into a weapon and destroying a weapon. So what were you planning on doing? Were you planning on injuring your sister? Then why would you even do this? I don't understand what's wrong with young people today. You're bringing nothing to the table. You don't have your GED. Public education is free. And as I tell everybody, people come over here from other countries, don't even speak English language. And the next thing you know, that person is the valedictorian of your school or first in your class because other people don't want to take advantage of the free opportunities that you have here. Slaves were not allowed to read or write. And they ended up sometimes to their detriment, to their death, learning how to read and write. And here you are with free education and you don't take advantage of it. All you're doing is hanging around with your hoodlum friends. And I'm going to say hoodlum friends because they're not up to anything. You're not up to any good. You're at the Bexar County Jail. And I'm sure your attorney told you not to make phone calls. You're not listening. And probably if you didn't make that phone call at the jail, you probably wouldn't even be here. And don't tell me you didn't know the phone was recorded, because every time at the Bexar County Jail, and I would tell my clients too, I don't know why you get an attitude with me, because I'll give you 180 days at the state jail facility to give you a little taste of what it is. I know that every time there's a phone call made from the jail, what ends up happening is they give the defendant's name, SID number, and they tell you that this call is being recorded. But you still going forward with that nonsense, trying to injure your sister who's only 16 over a phone charger that probably neither one of you paid for. Your mom is probably the only person who's working, and you all are doing stupid stuff. And now look at you now. You're in an orange uniform, no education, with a SID number, and now you're going to be on paper and you're going to have this felony following you around wherever you go because you don't want to get your education and you want to hang out with some thugs because y'all are watching video games or whatever nonsense y'all are doing, Fast and the Furious or The Godfather, and think that this is what life is about. That whole little thing that I read in the waiver, you all could have ended up getting killed running around with a gun, you and your friend. All right, that is not Black excellent. And then you know what would end up happening? Your mom would have been crying on the news asking people to do a GoFundMe. I do think he needs some jail time. He has some issues. He has attitude issues, and he has learned nothing from this entire thing. So, counsel, do you want to tell me why I shouldn't give him a taste of the state jail facility to get his attitude in check?
Your Honor, I think he's been in custody for, I believe, 90 days now. And in speaking with him, he wants to get back to work. He wants to get his education. I think that that time period in the facility already or in Bexar County Jail has given him at least a taste of what it could be. And I think that in this situation, giving him the opportunity to get his education and get back on track is warranted. He's young, and I understand that he could be sentenced and go to a state jail facility, but I don't think that that would benefit him. I think that if we're looking at rehabilitation, getting his education, taking the courses that the state recommended, and doing what he needs to do while being supervised by Bexar County would better serve him.
State?
Your Honor, the defendant does not have much criminal history, at least in the way of any convictions. Given his age and given his acceptance of responsibility, the state would recommend going forward with our recommendation for deferred.
Do you have any children? Please tell me you don't have any children. Well, I want you to be truthful, but I'm hoping you don't have any children because you're not ready for them. Do you have any children?
Thank you, Jesus.
Probation, what do you think about the conditions of MRT and anger management?
Judge, I think those would be good. I would also probably add the safety course.
Okay. All right. Thank you. All right. The court will sentence you to 4 years deferred adjudication. There's to be no contact with Carlicia Johnson. And you say that he would be living with his mom. Where is the 16-year-old going to be living?
That's his stepsister, Your Honor. She doesn't live at the same residence.
All right. So there'll be no contact, proof of employment within 30 days, regular reporting by Zoom or in person, regular random UAs, 100 hours of community service restitution. You're either obtaining your GED or you're going to obtain some kind of trade school certificate. Do you understand? Once he does that, the community service hours will be deemed satisfied. Anger management, firearm safety course, the MRT. The MRT is supposed to help you make decisions, correct decisions, think things through before you act. Now, with regards to the TAP evaluation, have you used any drugs in the past? No marijuana? No alcohol? All right, TAP evaluation, that can be done out of custody. I'm going to want field visits 1 time per month for 8 months. All right, we can go off the record. Good luck to you. You had better start making better choices. Yep, still has the attitude. I still think I should have sent him to prison.
Oh, I really think Judge Boyd should have, as doing so, may have changed his life and maybe, just maybe, NASA, but more likely JAIL.
Don't ever scold me. Do you understand?
I want the truth. You can't handle the truth.
All right. So who were you, sir? Okay. You sent me something filed May 16th. That was 2 months ago. And I read this, and you want to represent yourself, right?
That's correct.
Tell me why.
Well, I don't feel that my constitutional rights are being
Your what?
I don't believe that my constitutional rights are being respected.
Which ones?
Fourth Amendment. The Sixth Amendment.
Tell me about the Fourth Amendment. What about that?
Well, first and foremost, I don't believe that had any probable cause for the warrant. We have any
The warrant? Which warrant?
you heard it first, murder charge. 22-409.
You mean the warrant that was issued?
Probable cause after that.
Oh, okay. You know, notwithstanding the probable cause affidavit, a grand jury reviewed this and indicted you. That's the way they based it. Yeah. So just because you may have been arrested from an event. It was later, it was on October 7th, is what it says. But the grand jury in November reviewed it independently and elected to find probable cause existed. Plus, in the indictment, it's showing that you have 3 prior convictions, one in 2003, aggravated robbery, 2 assaults in 2012. The way this is worded, you are an habitual felon here. You're looking at no less than 25 up to life imprisonment years in prison. Do you understand? You understand?
No, I understand that. That's not what we're talking about.
I'm talking about it, and that's what we're going to do, is what the court directs, okay? We're going to talk about the issues that we have to deal with on the record.
Right.
And that first thing is, do you understand fully what you're facing here and what you're charged with? All right. Now, tell me about this Fourth Amendment issue.
Well, the Fourth Amendment issue that I'm speaking of is that specifically the probable cause affidavit. What I'm saying that the athlete didn't have any probable cause for arresting, which is not I'm challenging the veracity of the probable cause affidavit. I don't believe that he's a credible person to make the affidavit.
It's not a Fourth Amendment issue, Judge.
It's not.
Huh?
It's not a Fourth Amendment issue.
I let him talk.
Okay, let me read it. How about that? I'm not as well versed as y'all. I'll read it to you.
Read what? You have a waiver of counsel petition.
That's what we're talking about again?
Yeah.
Okay.
Yeah.
So
yeah, I'm reading this. Okay, so
what I was saying is,
what is it? That's a legal issue. It
Right.
doesn't have anything to do with whether you want your lawyer to represent you or not. That's a legal issue that's been addressed. It's sent to me, and I make the choice. I make the decision on legal issues,
Right.
not juries.
Right.
Juries decide facts.
Okay.
So let's talk about what it is, why you want, the issue is why you want to represent yourself and not have an attorney represent you.
Because I don't think I'm being afforded a meaningful opportunity to present a defense.
What is the defense?
What do you mean?
It's 4 words. What is the defense you're talking about? What is the defense? What is your defense you're saying he's not going to present?
That someone else committed the crime.
Oh, okay. Well, that's what every trial is. Every trial is about who is the person who did it.
I want to exercise my Sixth Amendment right to move forward pro se.
Okay. All right. You're going to get to do that.
Thank you.
All right. And you don't ever scold me. Do you understand?
Totally.
All right. You can represent you. Generally, people fail in that regard, but some have been successful. And you certainly have experience. You have 3 felony convictions alleged here, so you know what the processes are. These 3 convictions, were any of these trials?
No, Your Honor.
Those were all pleas?
Yes, they were.
How many trials have you had?
None, Your Honor.
You've never had a trial. Okay. All right. So you've thought about this long enough, and this is what you want to do, correct?
Yes, sir.
You're going to get a chance to do that. And we'll set this for trial as soon as possible. You'll get to represent yourself. You have to realize that you have to follow the rules of evidence. You have to follow the rules of criminal procedure. You have to follow the rules of the penal code. The fact that you might be not be trained in that is not an excuse. Everybody has to meet the standards of those rules in a trial, or else you don't, in many ways, get what you were seeking accomplished.
Mm-hmm.
But that's your choice. You understand?
I do.
All right.
Your Honor.
Then your wish will be granted. We will set this for trial. When can y'all be ready for trial?
Judge, we are ready. I will advise that we need to be specifically ordered to provide him discovery if he's going forward pro se. So I'd ask the court to go ahead and do that today so that we could start
It
making
is
copies.
done. Consider it done. I want this tried in 6 weeks. Okay. That gets you quickly up here.
But,
Anything else?
yes, sir. The discovery, will it be turned over to me so I can prepare for it?
That's what he just said he's gonna do.
Yeah, I didn't hear when I was.
Yeah, that's what he's gonna do is, I want that as soon as possible. Okay.
Can I, well, on March the 13th, you also told him to turn over to Discovery in 48 hours. That never was done.
Do that. Whatever you have, turn it over to him. Make copies of it and then give it to him. Go ahead.
I gave him what he was entitled to under the Discovery Rule of Code of Criminal Procedure. I did not turn over my entire discovery file to him.
Okay, what is it?
I personally would prefer that the DA do that.
Well, what is it that was a work product of yours? Is what you're saying?
Well, it was things that are specifically excluded under Code of Criminal Procedure that I cannot give to my client.
What he's referring to, Judge, is the statute that says that he can't give individual documents to the client. However, we've gone.
You're
going to
give it. You're
right. We will,
given
and
to Mr. Reynolds, you're going to give to him.
correct. And what I'll advise the court too is
that will be all.
we just dealt with this issue not long ago. The court specifically ordered that the documents be turned over, and that was sufficient to, get through that exception in the statute.
Well,
Can I, what exactly will be turned over? Could I know that specifically? I mean, I understand that things that he's saying that I couldn't have or things that were covered under any kind of exculpatory evidence in Michael Morton Act, Timothy Cole, but yet he still told me I couldn't have.
you're going to get that directly from him.
And what is that? Because he's saying that.
I don't know what it is, but I'm ordering both. I don't want to find out later that wasn't done. But whatever you've received has come from the
Yes, sir.
prosecution. Whatever the prosecution has given you is ordered to be given directly to the defendant.
And that would be.
Okay.
There'll be a sheet that gives you a summary.
Anything else? That is all. Okay. And let's be ready for trial. I don't want to lollygag on.
Sir, I don't want him as my second. I don't want him sitting on the side of me. I don't want any help from.
You're not going to. You won't need it. You'll be representing yourself. I'm talking to everybody here.
Thank you.
Is that clear?
Yes, sir.
All right. Thank you.
You know what gets to me in regards to this case is that you can actually sense that the accused has half a brain, the other half not so good, but the half that works must be able to read, comprehend, and recall, as I didn't see him look at his notes when he was referencing the case charges, which shows the difference in not just what they say, but how the judge and others around them treat them, instead of the sovereign citizen who rants and raves about them not being a person and sounding exactly how they are. This guy knows that if you're going to fight the system, you have to understand how to use it first. This is why it takes a minute to realize he's not a sovereign citizen muppet, but half a smart cookie. I'll try and follow him to see how he goes, and he'll pop it up so we can all follow him if I do. Until then, all of you that have stayed this long in this episode, I would like to say to you all, I'm in the bath.